Okay, so we're almost there. Everything is just getting ramped up. Okay, so we're on. There we go. Okay, so we are in business now. Okay, and hopefully everyone can see my screen. And I'm just going to go ahead and get us into presentation mode. Now, what I have discovered just with my own personal bandwidth, you'll see that the captions are coming up. I am actually going to close those out. However, if you do need the captions, I do know that there is a way to access it on your side, but during the playback, there will be captions added there as well. So if you need them, they won't, I'm going to actually inactive them now, just because, again, my bandwidth has been spotty. And what I have just seen previously is that if I disable captions, for whatever reason, it does give me a little bit more, I would say, bandwidth to ensure that we do not lose connectivity. Okay. All right. So let's get started. So I am sure that you are probably familiar with this screen right here. You saw it in Unit 1. Here we are in Unit 2. Those numbers just look a little different, right? So as you can see here, the PHR has a focus of about 14%. That actually has decreased. I want to say it was 16%. 16% prior to March of this year. So PHR has reevaluated just the weight of this particular section as it relates to the PHR. Now, the SPHR is at 17%. Now, that did increase effective March 1st of this year. And so, again, that S just stands for that more strategic focus. So, you're looking at things from a global perspective. Whereas the PHR, you're more going to be domestic, but not to say that you wouldn't have like a question or two that maybe focus on just that elevation again from that global perspective. And then for SHRM CP and the SCP, nothing has changed there. So it's still weighted between that 14 and 18%, depending upon if you're taking the CP or SCP. As you can see here, our focus is going to be on the people in the workplace. I like to say all five of these units that you are going to encounter focuses on people. I'm like, we are a people organization or a people department, right? So why wouldn't it focus on the people? I will say for unit 2, it probably focuses, puts the emphasis on people because this is where we start to like generate the candidate profile. And we'll talk about like recruiting and the recruiting process, the hiring process, the offer process, the retention process. All of that is going to be discussed in unit 2. So again, there's just I would say, a heavier um, focus on people as it relates to this unit. If you have your book handy, again, you'll see that as you have flipped through the pages, again, it does have that familiarity of Unit 1. So it's going to give you just the highlight reel or the table of contents of what to expect out of each section. So I always like to tell the learners, make sure that you're just reading through those. It kind of breaks down what to expect. And then it also at the end of each section, what you should know or what you should have learned through that particular section. Also, at the front of each section you encounter, it's lists, what you should be able to, you know, digest or be able to recall again from reading the section. I'm sure just going through unit 1, you've come to the realization that we don't touch on every topic that is in your book, but absolutely during your downtime, that self-study time, making sure that you are reading those additional sections that aren't called out in particular to class time as well. So I'm going to go ahead and get us started with our learning objectives. So we here in Unit 2, We are going to talk about adhering to employment discrimination laws and know how to apply them. Calculate adverse impact. So I don't know if anyone likes to, play around with math and calculators and numbers. From my understanding as an HR professional and other HR professionals, that's not our strong suit, but it's going to be all right. Thankfully, just in, I would say, feedback received, adverse impact doesn't always come in the form of a calculation. Adverse impact, when we get to that, can come in the form of just being able to transfer knowledge. So having an understanding of what adverse impact is and how it can, I would say, just complicate how we recruit. And we would just want to make sure that we're coming from, a compliance perspective, a human perspective, and thinking about just all types of imposed risk as it relates to just some of the things that we do in the hiring process, such as assessments. Again, job descriptions, all of that can have an impact on adverse impacts or impacts adversely. Lastly, we'll define and explain federal employment legislations as well. I like to think that we'll probably define and explain federal employment legislations, and then we'll wrap up with calculating adverse impacts. All right, so let's get into it, shall we? All right, so right out the gate, we have our Civil Rights Act of 1866. So in particular, we'll be talking about Section 1981. Before we get into a little bit more of what you're seeing on the slide here, I do want to just call out now as it relates to your exam. Your exam likes numbers, they like dates. So try to keep that in mind as you are progressing through the 16 weeks. So it's important to know what Section 1981 is referring to, because you may get asked a question related to Civil Rights Act. And we're going to talk about the evolution of the Civil Rights Act, as well as we talk about it in its current form as in today. But it's important to know about Section 1981 in particular. So as you can just see here on the slide, right, it was founded on the premise to prohibit discrimination on the basis of age, race, religion, sex, or disability. We also know today that that is really comprised of what we, have called the Title VII. And we also know that there's probably some additional language in there as well. If you were to go to, your employer and pull up their EEOC statements. And, if you are in the swim lane of orientation or onboarding, you may also, share something very similar to what you see on the slide here with new hires as it relates to, the non-discrimination in the workplace. Now, Section 1981, as you can see, there are a couple of bullet points. These are great key takeaways. As Section 1981, it applies to racial discrimination in employment relationships. It does guarantee all persons to the same rights across the country to enter and enforce contracts. That is, I would say, a big key takeaway there as relates to Section 1981. And then the statute of limitations there is noted that it is up to 4 years from the violation. Now, it is also important to know that what Section 1981 included and what it did not include. So Section 1981 does continue to serve as the foundation for pressing charges of discrimination. Even though, again, as we progress through these slides, you're going to see just some additional acts come into play. But I like to call this as the trailblazer of just equal rights, especially in the workplace. Now, Section 1981 did not protect against political rights during this time frame. So we're talking about voting, holding office, things of that nature. Social rights, equal access to public accommodation, those were not a part of the Civil Rights Act. And so again, those are just some, I would say, some knowledge, fun facts to know about Section 1981. Now, as we progress forward just a little bit, getting, to 1964, this is where we really talk about that Title VII action going on here. And so as you, again, just reading off of the slide, it prohibits discrimination in employment on the basis of race, color, religion, sex, or national origin. Now, again, as I shared, your exam does like numbers. And as you can see, there's a number that is highlighted in bold red font here that is should serve as a key takeaway. So this applies to those employers with 15 or more employees. So it is a very insignificant number, right? So if you have 14 employees, Title VII would not be applicable to that particular employer. So, but those are going to be more of your mom and pop shops, maybe some startup companies that really just do not have I would say, the head count to enforce Title VII. So that is very important because your exam may ask you, who falls under Title VII or who is exempt from Title VII. And you would want to share like any employee that is less than, 15. It does apply to employment agencies, labor organizations, state and local governments, and also those educational institutions. So we're talking about the public and the private sector here. It established the Equal Employment Opportunity Commission. So the EEOC is probably how we speak, on a day-to-day basis when we're talking about discrimination or Title VII in the workplace. And it outlined the procedures that the commission should follow to prevent unlawful employment practices. So again, just some fun facts there, but one of the biggest takeaways here is it is applicable to those 15 or more employees. Now, I will also share as it relates to Title VII of 64, there is a section in there, Section 703. It's also noted in your book as well. And just paraphrasing and going straight to the book and reading that it shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge an individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment based on, again, those Title VII, race, color, religion, sex, national origin. And then it also goes into mention like limiting segregation or classifying employees or applicants for employment in any way which would deprive or tend to deprive an individual employment opportunities or otherwise adversely affects, again, going against those Title VII implications. So race, color, religion, sex, national origin are also applicable there as well. So the act also established, again, the EEOC Commission. And again, it did outline those procedures, right, that should be followed to prevent unlawful employment practices. And here is this call out. This just did take place not too long ago, about 4 years. And I can't believe it's already been 4 years since this has been implemented. But if you all recall, in 2020, there was a lot going on. The world was on a shutdown. There was, a pandemic that was running rampant just globally. And at the same time, there were some wins that took place there as well. And one of those wins was related to the Supreme Court ruling of 2020. And as you can see on the slide here, just those titles have protections based on sex now include gay, lesbian, and transgender persons as well. And the book does also call that out a little bit further in the section, but I'm glad that it's also noted on this slide here just to kind of bring awareness as we're talking about Title VII. All right, so now let's advance forward a little bit more. So now we are in, the 90s. So 1991, we're talking about the Civil Rights Act here. And so here it defines which actions are discriminatory. And then there's some procedures that should be followed in order to prosecute. And so, it's important for everyone as an HR professional to make sure that we have proper plans, procedures, right, in place, guidelines, protocols, so we know what to do in certain scenarios. And so this act really serves as that foundation, that standard operating procedure, those work instructions on what to do and how to do it. Just some clarifications that are called out here is, understanding the shifting the burden of proof, particularity, foreign practices, race norming, motivating factors, and then remedies. And so, just kind of going to the book here again, I'm going to talk about some key takeaways, and then I'm going to get into these clarifications here. Just so you are aware, the Civil Rights Act of 91 is the most complete civil rights legislation since the Civil Rights Act of 1964, right? So our founding father, that trailblazer, and now we are here in, again, 1991, and now we have the most complete version here. Another key takeaway is the ability to provide injured parties with punitive and compensatory damages, which is going to be talked about in our clarifications. And then also, employees here can select trial by jury rather than judge alone. So now they are able to, have a jury of their peers hear the case and make a decision from there instead of just the judge hearing and then deciding on judgment. Now, when we talk about clarifications, the first one here is shifting the burden of proof. And that was a game changer when we talk about Civil Rights Act. Because now we are kind of in a dialogue per se, right? So when we have the plaintiff and we have the defendant, or we have the employee and we have the company, now we're being able to have dialogue to really determine what the discriminatory practice is. So the worker is allowed to bring a complaint, and that they must show prima facie evidence of discrimination. And so prima facie is just on its surface or on its face. So that foundational first glance, what does this look like, right? So now the employer or the worker will file a complaint. The company has to come back and they must show why the business practice has been justified, right? And so it cannot be a BFOQ. And so we're going to talk about what that means here in just a little bit. But it can't be a bona fide occupational qualifier, as that BFOQ acronym stands for. The worker must show that the employer's practice is a pretext for discrimination, or there are equally good procedures that have a less discriminatory impact. And again, that's where the employer will be able to come back and debunk or have a rebuttal as to why the practice was instituted, and has it been validated? Is it accurate? Does it create any adverse impacts against the person that is bringing, or against the group of people that may be bringing the complaint to the employer's attention? Particularity here is when job applicants claim that the hiring process is discriminatory. And so again, they're kind of going through that shifting the burden of proof as well. But during this process, we know that they are considered applicants. So there is just a slightly different process. And so if you've ever, had an employer that provided an assessment, and maybe your current employer does, when they are going through their candidate profile, and they're like, I want to send this candidate for testing. We want to make sure that, again, the test is valid. We want to make sure that it's accurate. We want to make sure that it doesn't have any adverse impact. However, in certain situations, applicants can come forth and say that there was discrimination in the way that the hiring process takes place. So that is particularity. Foreign practices kind of work the same way as particularity, only in a foreign country. So some of those the U.S. laws are applied more broadly when we're talking about workplace discrimination. Motivating factors. Most charges of discrimination, race norming. So the law prohibits race norming, and this is what would happen if someone was to intentionally go in and adjust test scores. And I like to apply the visual of, if you've ever high school, college, you may had a teacher or a professor, and they're like, I'm going to grade on a curve. Right. And so sometimes it works out to your benefits if you're if you're not like the high A plus student, you're like, oh, I really needed that C. And if a professor or a teacher grades on the curve, then you might be able to get to that C. Well, you don't want to take that same type of action when it comes to assessments because now you're starting to adjust scores and there could again create some discriminatory issues to arise such as adverse impacts where now you're excluding a group of people based off of the assessment. So in one world it may work well for students while in other such as recruitments it doesn't work so well. So brainstorming again just kind of like the book shares, maybe adjusting those test scores or using different cutoff scores to again exclude a group of people from being passed on in the hiring process. Motivating factors. So most charges of discrimination are not simple cases where an employer's actions are just based on a single discriminatory motive. Some of them may have mixed, motives. The book does give an example where a female is passed up for promotion, both because of inadequate performance and because her behavior does not fit a traditional stereotype of how a woman should act in the workplace. And so it could be convoluted. So we want to, make sure that we aren't, again, applying any discriminatory actions when it comes to the reason why we are taking the action that we are. And then remedies, just talk about kind of the key takeaways that I had shared, where now employees can select a trial by jury. Punitive and compensatory damages are also included as well. So that is remediating the situation. And so we do have the Civil Rights Act of 1991 to thank for all of this. So again, the most comprehensive act that we have right now today is what we see on the slide here. Oh, and I always forget to show like the pop-ups. So, and this is taken straight out of your book as well. So kind of again, looking at that back and forth, that dialogue between the employee and the company. All right, our first knowledge check question of the evening. So the 1866 Civil Rights Act, Section 1981, guarantees that all citizens of the U.S. have equal rights to what? What do you all recall? All right, I see responses coming in. All right, and so I think the responses have slowed down a little bit. So the correct answer here is B as in boy, to make and enforce contracts. So C is to hold a job. Um, so the Civil Rights Act doesn't actually say that an employee has to hold a job per se. Now, they say if you're going to hold a job, then there cannot be any discriminatory practices. If there's discriminatory practices, the employee now has a right to file a complaint and go through that burden of proof, right? But what 1866, that the foundation Civil Rights Act. So this is that very first one. We're talking about Section 1981. So again, it was kind of light, right? It was not the most comprehensive. And so it really was like the employee can, or the employee can make and enforce contracts. So B here would be the correct answer. Okay, let's keep going. And so this next slide here talks about that BFOQ, or again, that bona fide occupation qualification. So most of the time in conversation, you're going to hear just people use BFOQ because bona fide occupation qualification is just a mouthful to say when you're trying to talk to someone. So if you're not familiar with the acronym, I would familiarize myself with this one as well. This one has shown its face just in most recent feedback as being something that is on the exam. Now, again, just reading through the slide here, you see it permits discrimination on the basis of religion, sex, national origin, only when these attributes are reasonably necessary for the operation of the business. So a bona fide occupation qualification, BFOQ, says, yes, I am going to grant exceptions when an exception needs to be made on the basis of religion, sex, or national origin. The one thing that you do not see up here is race, because BFOQ should never come into play when we are talking about race of an individual in employment. Now, as you can see here, when we're talking about religion, it does mention the sacrifice the rights of other workers, break collective agreements, and suffer lost work efficiency and de minimis actions. And so that's when we really should not base any type of hiring decision if any of those are going to come into play, right? Social norms, authenticity, biological equipment, and then going to like national origin business, impairments of business operations. And so let's just spend a couple more minutes here and talk about just discussing BFOQs. And so in the chat, if you wouldn't mind throwing out some examples when you think a BFOQ would be applied in a hiring situation. Because we know Title VII already says we cannot, discriminate based off of race, religion, sex, national origin, right? And now we have BFOQ saying, well, wait, I think it might be okay under certain circumstances, right? Andrew, yes, modeling, right? That is a very niche, I would say, industry, and they're looking for specific people, right? So modeling, you could see as it relates to sex, right? You're looking for male or female, just depending upon the type of modeling that you are looking for. Andrew, you're going to have to give me a little bit more about an employee referral because I might have to err and say, no, that is not it would not fall under a BFOQ, but give me a little bit more insight. Sarah, absolutely. We're talking about religion, right? A Catholic school teacher in a Catholic school, right? We probably don't want a Methodist school teacher, although maybe there are some similarities, but it's not a Methodist school. So yes, we would, have a job description specific to or specific for a Catholic school teacher. Yep, Andrew, acting, absolutely, right? Leslie, escort, interesting. Carol, locker room attendant, another great call out as well, because you're going to have a male locker room attendant and a female locker room attendant. I actually get that one a lot. So, yep, renew hiring a male candidate for night shift. Now, see, I don't know that one's going to be a BFOQ. You might run some risk there because, and remember, and not just for BFOQs, but even going into your exam, remember you should be justifying your answer. So if you say hiring a male candidate for night shift, what would be the justification as to the reason why you would only select a male candidate or a male person for night shift? And that, I think, if you, talk through it, is your selection going to create an adverse impact to other groups? Angie, I would also say the same, like correctional officers. Again, we want to be mindful of not placing stereotypes, on certain careers or job titles. So again, you want to ask yourself, like, why wouldn't I hire a male or female, person for this particular position? Tiffany, you say someone that is bilingual. You know what? That could be a preference, but I don't know that it would fit a BFOQ. And so they could put in, and I have seen in job descriptions where they will give the job descriptions, they'll give preference to someone that is bilingual. But again, we wouldn't want to be discriminatory against anyone or any person that is not bilingual. Jennifer, male in a women's dressing room, right? Especially, if you're thinking about it, if it's closed in, because, and we want to be very, I would say, sensitive about that as well, because, you can go into Old Navy, and I think that their dressing room is it's like pretty open. So anyone could probably, put you in a dressing room. But Jennifer, just one that might be closed off, where I'm just trying to think of like a store, because I think a lot of stores are now pretty much universal in their dressing rooms, but I know just in years past that hasn't always been the case. So I think we've actually moved away from being gender specific when it comes to dressing rooms, but in certain situations that might be applicable. But I would think in most situations, it would not fall under a BFOQ. Nancy, yep, camp counselor at a girls' camp. Yes. Jason says a patient, intimate care preference. Yep. And again, I like the way that you use preference, right? And so we want to make sure is it a preference or is it a BFOQ? Just in other cohorts, having a wet nurse is, some of female, and I don't even know if that is truly like a male dominated position even. So more than likely you're going to have a female person. Of course, they are probably more equipped to handle it. That could be considered a BFOQ. Myra, you said a doula. Myra, you know what? It's so funny that you say that, because I was watching a program on the news last night, and there was a male doula. There's a male doula program. And that was like the first time I had seen something like that. And I was like, you know what? I was like, I thought it was great, first and foremost, that we have male doula. They came from the lens of preparing fathers to help with the mother that is going to be laboring. But more than likely, the doula that you are probably speaking of is female. So there could be a BFOQ for that as well. Renew, yes, bilingual as a requirement. There you go. And so, yes, bilingual by itself is not a BFOQ. To be bilingual as a requirement, you could put that in the job description. Again, it could be, and I don't know if we talk about that in this particular section as a basic qualification, or an additional qualification, because our basic qualifications are going to be those KSAs, right? So those knowledge, skills, and abilities. Whereas in job descriptions, you may put that under like additional, like bilingual as a preference for this position. Yep, Angie, and I totally get it. But remember, we want to be able to take certain stereotypes out. So placing physical prowess or the ability to handle potential violent situations. And if I'm speaking, candidly, you're probably not going to get a lot of female applicants, but we do not want to put out that we are only looking for male candidates, right? You could have a fit test, right? And when we talk about assessments and fit tests and things of that nature, we also want to make sure that those tests that we are, giving out are one, required, two, that they have been validated, three, that they're reliable, and four, that again, they are required to do the job. Because we still would not want to put a BFOQ emphasis on a correctional officer where we are weeding out a group of people. Does that make sense, Angie? Perfect. Yep, Cheryl, reading your comment there, worked at an immersion school. Is that engineering teachers, maybe English teachers? So specific language was English and Chinese. Okay. I was like engineering, English. So yes, so specific language was required. So that's when, yep, you would have not necessarily, it would not fit into any of these as a BFOQ, right? So again, you have a requirement for a language, but it's not going to be based off of religion. It's not going to be based off of sex. It's not going to be based off of national origin, and it's not going to be based off of race, right? So an English person, or someone that speaks Chinese could come in many different forms, right? So again, we don't want to, and we want to make sure when we're taking the exam that we are not putting in our own narrative as well. So I know even for me as an HR professional, I'm like, you know what does, would, speaking a different language or an additional language, being a BFOQ, it actually does not meet, the criteria to be a BFOQ, but we still would want to be open, right, to filling those positions. And, maybe you're looking for a candidate pool, a pipeline, and you want to open it up. And again, your preference is to have those languages because that is the language that is spoken at that school. But it would not fall under the category of BFOQ. Great conversation, by the way. Um, so now let's turn and look at some disparate treatment versus disparate impacts, because this is kind of getting into not our BFOQ, but now we're going to talk about like assessments, and when things are intentional or when they're not intentional, because there are, I would say, people out there that do things very intentionally, but there's also a group of people that meant no harm and didn't realize that, it was discriminatory. And so we just want to be very cognizant of that. So there's two terms on this slide. They look very similar, right? You have disparate treatment and you have disparate impact. What I want you to take away from this slide is the difference between the two. So disparate treatment occurs when a person is treated differently because of their race, religion, sex, or national origin. And so as you can see there, disparate treatment is intentional. So if we look at disparate impacts, we know that is unintentional. So this just involves that unintentional discrimination and can be proven through that burden of proof or just some additional work called, adverse impact or the 4/5 rule. We're going to talk about that here in just a minute. So with disparate treatment or disparate impact, we often apply, I would say, treatment. The intentional probably is a little bit more obvious than the unintentional. And so an example is, and I give a call center example from a previous life of mine. And, if someone is being trained, right, and they get 3 bad reviews and they're let go. So it's like 3 strikes, you're out rule, right? So let's say that this person files a claim because maybe they've observed other people in the workplace get multiple chances to recourse, right? They get multiple coaching opportunities and they weren't let go. So this person does file a claim. What EEOC is going to do is that they're going to come in, right? They're going to look for any derogatory remarks, if they were made, how often that race was hired, or separated from the company. So they are going to come in and do their own investigation and render judgment from there. Right. And there's a whole process with the EEOC. And I don't think we're going to get to that tonight, but Deborah will be able to share in future class sessions what that process looks like. But just know that treatment is intentional. Unintentional may be, again, something that we just simply was not aware of. Maybe it's some rules, maybe it's policies that appear neutral and result in disproportionate impact on particular groups. A job description, right, could have language in it that is male dominated. And so therefore, you're only getting male candidates because that's how your job description is written, until you actually read through and you're like, no wonder why we're not getting, female candidates, because of certain language that we use. And so we go back and we rewrite our job descriptions and we put in neutral language in there. So again, just some things that would be unintentional that we can course correct would fall under the impact. So just again, treatment, intentional, impact, unintentional. Also, let me see here. Oh, okay, I'm gonna just back up because I thought I had a slide on this. So in your book, it does talk about the Supreme Court case of McDonnell Douglas versus Green. And so this one is a very interesting case. It obviously went all the way up to the Supreme Court. So there's 4 call outs here. And so paraphrasing, so if you have some time, I would go to like case, I forget, it's case.net or something, and look up the McDonnell Douglas versus Green case. It's a very interesting read. And so it does involve a Black male with an employer. And so the Black male obviously is a part of the minority group. It's a protected group. This particular person was let go of their position and objected to it. So they went and boycotted the plays, and I think may have created some just additional chaos within I would say, the parameters of where the employer is situated. So the person was let go, right? So now the employer is backfilling the position. So McDonnell Douglas is like, hey, I have this job description here. I need it filled, put it out there, and start sourcing candidates. Well, none of the candidates that were sourced met the requirements of the job, and they just really didn't have a strong candidate pool to pull from. So you know what Green does? Well, he's like, that's my job. I want it back. I don't feel like I did anything wrong. I felt like I was let go unjustly. So let me go and apply for my job. Right? You're like, hey, I got this in the bag. You thinking that you're just going to go in and nail this interview and you're going to walk away with an offer that day. Well, that didn't happen to Green. He didn't get his job back. And McDonnell Douglas gave some canned response as to the reason why Green didn't get the job. Maybe they said, well, we already have someone for the position. Thank you for applying. Well, that turned out not to be true because the position for McDonnell Douglas stayed open and remains open for quite some time. So now Green is like, well, you told me I didn't get the job. I know I'm highly qualified for the job and you didn't hire me and the job is still open. So now I'm going to go and file a claim of discrimination. And so that's what happened. So Green filed a claim of discrimination. There was that burden of proof, right? So Green is saying one thing, McDonnell Douglas is saying another thing. And so it makes its way all the way up to the Supreme Court, in where they did finally just the judgment or ruling was in favor of Green getting, that position um, with McDonnell Douglas. And so it was based off of Section 708, and the discrimination that Green filed was based on race. So again, and I'm paraphrasing here, but a great, I would say, case to just read through, just to kind of understand kind of that disparate treatment versus the disparate impact, in particular with this case here. All right, so if you have a discrimination policy at work, I'm pretty sure it includes some of these protections here as it relates to Title VII. So racial harassment, sex discrimination, and religious discrimination, if I can get my words together this evening. So racial harassment, not an exhaustive list here, but we're talking about racial epithets, derogatory comments, verbal harassment, racist jokes, name calling, degrading, belittling, all of that misconduct. Some of this can, for I would say employees, winds up in a gray area where they're like, oh, well, I was just playing. Well, the person didn't think you were playing. And, I think it's, being insensitive or inconsiderate for all individuals. And so that's where, HR again would come into play. We have respect in the workplace training, or you may call it something else within your organization, just so again we're bringing awareness to what could be considered racial harassment in the workplace. Sex discrimination is up here as well. There is that term there that we're still using today called the glass ceiling. PDA is also up there as well. That's just referring to that Pregnancy Discrimination Act. In Sex Plus, which has been added most recently, and that does include the non-binary, transgender, intersex individuals. And then we also have the ruling from that 2020 Supreme Court ruling that came down just a few years ago as well. Glass ceiling probably is a term that we're all familiar with, but just to kind of bring more attention to it, just because it has been on exams in the past, but of course, excuse me, that this is really, I would say, more so for women in the workplace who have been discriminated against, where it really limits their career advancement. If you've ever heard the phrase like the good old boys club, where women don't get to go golfing, or they're not part of those spaces and places where male leadership are having conversations and getting to know each other, really hinders female promotability in the workplace. And so a lot of times women may feel like they have hit a glass ceiling within an organization because they just do not have the, I would say, exposure as some males in the workplace do. So that still is existing today. Again, just want to bring more attention to glass ceiling than some of the other ones that you have listed there. Sex Plus is a relatively new one, so you may see that one also called out in your exam as well. When it comes to religious discrimination, that's a reasonable accommodation without creating a hardship on the organization. And so that comes in many different forms. So as you can see here on the slide, the sacrifice the rights of other workers, breaching any collective bargaining agreement. So we're talking about union activity there, suffer efficiency loss, right? So a loss of productivity in the workplace, or any additional like de minimis action there. So with pregnancy, with religious discrimination, and I'm going to just call out a remark made in the book as it relates to the 2015 U.S. Court against the EEOC versus Abercrombie and Fitch. I have not checked recently, but on Netflix, they actually talk about Abercrombie and Fitch, and really, I think, putting them, exposing them for just some of the bad behavior. I want to say it's called White Hot. White Hot, I think it is, on Netflix. You may have watched the documentary. I thought it was very insightful. I watched it a couple of years ago, so it is relatively outdated, but it may still be on Netflix, or you may just be able to find the documentary just by doing a simple Google search. Again, another great case to read through as it talks about religious discrimination. I don't believe Abercrombie and Fitch probably would have had the exposure if it wasn't for this particular individual in this case who actually came forward to talk about the discriminatory practices that were being had in Abercrombie and Fitch. There was also some other individuals as well that came forward after this person here, but there was a female applicant who wore a hijab and was not hired. And it was found it was because she did not fit the I would say the profile of an employee that would be working for Abercrombie and Fitch. Abercrombie and Fitch never asked if the applicant needed a workplace accommodation. They just simply wrote her off and went about their day. So the court did rule in favor of this young lady, obviously under the religious discrimination perspective there. The book also does share on the flip side of things another case. This was the Supreme Court in Hardison versus TWA or Trans World Airlines. I don't know if anyone recalls TWA, but this was a case out of 1974. And so this particular situation, this person asked to be off of work to observe their I believe it was their Sabbath. Yes, it was to observe their Sabbath. And TWA actually went through leaps and bounds trying to make accommodations for this particular individual and was met with rejection, each and every way. So this particular person filed a EEOC claim. Again, you go through that burden of proof, right? And actually, TWA was found not TWA, the person was actually found guilty of, what am I trying to say? TWA was found not guilty in religious accommodations. Goodness. And again, just kind of calling out sacrificing the rights of other workers to accommodate another employee, breaching a collective bargaining agreement to provide benefits or special needs, suffer a loss of work unit efficiency again, and then provide more, than a de minimis action. So we're talking about, having someone work overtime. Thank you, Nancy, not liable. So having someone like work overtime could create unnecessary hardship on a company or, moving around shifts to accommodate someone being, out of the office or out of the plant on a Saturday to observe Sabbath. So again, TWA did provide accommodations. The employee, unfortunately, did not like any of those accommodations. And so again, TWA was not found liable as it relates to religious discrimination. Okay, quick knowledge check. This one is a fill in the blank. If you do have fill in the blanks on your exam, you want to make sure that you are as accurate as possible, unless the exam would count it incorrect. So let's try this one out. So the term blank blank refers to social barriers faced by women and minorities preventing them from being promoted. All right. That's what I'm talking about. So yes, glass ceiling um, is the correct answer here. So yep, and again, if you come into contact with fill in the blank questions on your exam, you'll want to, because it may ask you for a number, it could ask you for word, and you want to make sure that it is as close as you can possibly get it, right? So, you could probably fudge ceiling and put the I before the E, and they wouldn't count that out as incorrect. They just want to make sure, that it is saying glass ceiling. Now, you wouldn't want to say like glass wall. That would not be counted as correct, but some form of glass ceiling would be considered correct for your fill in the blank. Great job. All right, so now let's talk about the EEOC. So this is that Equal Employment Opportunity Commission. It was created to enforce Title VII of the 1964 Civil Rights Act. We already know that, right? Because we talked about that earlier. Again, I'm just going to say it. So you all retain it, but 1964 Civil Rights Act, most comprehensive, right? It does include, I would say, procedures on what to do and how to do it, right? Shifting the burden of proof. You got particularity in there. Most importantly, you have the remedies. I'm talking about judged by your peers, and also money would be paid out as well for any damages. There are some additional responsibilities as it relates to the EEOC. Excuse me, just one moment. Ooh. All right, sorry about that. I had to sneeze there. All right, so additional responsibilities. We're talking about age, the ADA, pregnancy, as you see there. Again, the PDA, disabilities, ADA, and then genetic information, the GINA, or what we like to call just the GINA Act there. As you can see, they do have a priority for systemic discrimination. So the EEOC does not have the same authority as other federal agencies to issue directly enforceable orders. So that is something that they don't have, I would say, governance over as it relates to the EEOC. But as you see, they do have a lot of governance over systemic discrimination and a lot of other acts that we have implemented, or I shouldn't say implemented, but have within our own workplace as well. The EEOC does have jurisdiction to investigate charges of discrimination, to attempt to reconcile the parties, to bring suits in federal courts on behalf of aggrieved employees, or to authorize the aggrieved party to bring suits in the federal courts by issuing a notice of right to sue. So you may have even received some of these letters to your workplace, especially again, if this is your scope of work of handling, discriminatory claims coming across your desk, that we handle those very sensitively and very urgently. So the EEOC does have considerable power because of its ability to issue guidelines, solicit charges of discrimination, conciliate an agreement. The EEOC has been given wide investigative powers, which represent a significant source of power for the particular agency. But again, just also noting that they do not have the same authority as other federal agencies to issue enforceable orders, even though they are very powerful. And again, they do have governance over a lot of discriminatory actions. So here are your procedures at a very high level. Again, if this is your scope of work, you're like, oh yeah, so this is what happens after I send in my rebuttal. So again, an employee or someone on behalf of the employee will file a charge, right? So the charge is filed by the employee. The EEOC will conduct an investigation. A Title VII claim is good for 180 days. So you do have 180 days as the statute of limitations. It can be extended up to 300 days if there's any additional like state agency, and if there's any law prohibiting the same type of discrimination as well. So it could be combined with other laws if it's related to certain types of discrimination. So just kind of keep that in mind. That's probably not something that you need to commit to memory, but it is a good to know. So again, statute of limitations, 180, but can be extended up to 300. The charge can be filed by the employee or someone on behalf of the employee. There will be an attempt at mediation and settlements because that's always the end goal. We want to, hear out um the uh the situation, right? We want to understand what the complaint is. We want to be able to take action on it, and we want to see if we can remediate it in house. However, at certain times, an employee does not want to go that route, and they can absolutely go one of two ways. So there could be an attempt at mediation and settlements, or if the employee wants to pursue further, again, there would be that investigation by the EEOC. Now, the EEOC just is not going to investigate any and everything. It has to be, I would say, um, findings of discrimination. So again, the first thing that they're going to want to do is really get a statement from the employee about the situation, and then the EEOC will determine if it is necessary to investigate. So again, we will try to mediate, and then the EEOC will determine if an investigation is warranted. One of two ways that this can happen. So on the left side of the screen here, you see that the EEOC determines no reasonable cause and issues that dismissal and notice of rights. However, it does not have to stop there. So the EEOC is like, no findings. They issue the dismissal and notice of rights to the employee, and now the employee may request a right to sue. However, when they do request the right to sue, now they do not have basically that stamp of approval from EEOC. They're like, EEOC is like, I didn't find anything, but hey, if you want to continue to pursue this, by all means, you can do that. Here are, your instructions on what to do next. However, they're going to bow out. On the flip side of that, the EEOC can determine reasonable cause, and then they will start to issue those letters of determination to both parties involved. There will be an attempt to resolve through conciliation. So again, this is just a form of mediation. So we're going to try to resolve before we need to go to next steps, and that would be litigation. So the EEOC would review the case for litigation and then make a determination there. So the EEOC will recommend against it. They will issue a notice of right to sue to the employee there, or the EEOC will recommend litigation and will take legal action. So it will either sue the employer, or we're going to go to court. One of the two are going to happen when the EEOC does review for litigation. Again, favorably, once an employee files a charge, you'd hope that you'd be able to mediate and settle it before it gets any further. However, in certain cases, it does go down the path of legal action, or sometimes it does take the path of a lawsuit against the employer. All right. So, and I believe we are going to spend the rest of our time today covering the adverse impacts in 4/5 rule. Let me see here. Oh, before we actually talk about this, I'm just looking through the book. And there is a header responding to an EEOC charge. One thing that I want you all to take away from this, of course, is kind of what the book says, but don't ignore it, right? You want to act with a sense of urgency. The EEOC will come in and everything is discoverable, right? As HR professionals, we know that we document, and then we document some more. Because if there is a discriminatory claim and we want to refute it, well, we want to present our evidence to say, no, this person was performance related. This person was conduct related. this person, did not meet the assessments, and here are our findings from the assessment that we give out to all of our candidates. So you never want to ignore it. You want to act with a sense of urgency. You want to preserve, right, your documents. You don't want to become frustrated about the situation, so you never want to act in retaliation. You want to maintain the confidentiality of this, right? Because the more people you involve, the likelihood of it getting, or gaining exposure within the company. And that's not something you want, because that could also come in the form of retaliation as well. You want to be able to prepare your position statements, again, refuting the claims. And then lastly, like the book calls out, just taking advantage of that mediation when it's going to be, most appropriate for the situation at hand. And you'll handle those EEOC claims on a case-by-case basis. All right, so now let's get up to adverse impacts in the 4/5 rule. So your book says that the EEOC does define the adverse impact by the 4/5 rule. This is a selection rate for any race, sex, or ethnic group, which is less than 4/5 of the rate for the group with the highest rates will generally be regarded by the federal enforcement agencies as evidence of adverse impact. So when adverse impact does exist, employees are expected, and not employees, employers are expected to either show that the selection process is valid, right? It has to be related to job performance, such as a fit test, such as maybe an honesty test, right? So it has to be backed by performance or the job description. And so if there is inconsistencies there, right? If we cannot validate it, as an employer, we have to stop using it, or we have to find an alternative process that has less discriminatory effects. So with that being said, there is an illustration in your book that we're going to walk through. So I did create this slide here just so we can kind of walk through the steps so you know how to complete a 4/5 word problem per se. On your exam, it's going to come in the form of a table. So you're going to have a table with some numbers, you're going to have groups of people, and you're going to perform a mathematical equation. Now, as you can see on the slide here, again, a selection rate for any race, sex, or ethnic group, which is less than 4/5, which is 80% of the rate for the group with the highest rate will be regarded as evidence of adverse impact. So your 4/5 or 80% is percentage of a lesser represented group equal to at least 4/5 a percentage of the most represented group. So if you come to a yes, that means no evidence of adverse impact. And if there is a no, there is evidence of an adverse impact. And hopefully this will all make sense here very shortly. So your 5 steps to determine adverse impacts. 1, you want to identify the policy or practice at issue. So again, we're looking at why do we have this policy in place to begin with? What problem are we trying to solve? 2, you want to calculate the rates of selection for each group that you have. So we're talking about male, female, we're talking about any minority group, so Black, Asian, Pacific Islander, whoever you have within your talent pipeline, your candidate pipeline. You're going to note which group has the highest selection rate. So which groups are being passed on to the next rounds of interviews. You're going to calculate those adverse impact ratios, and then you're going to determine if adverse impact exists. So this is really sharing with you how strong your hiring process is. And it's really going to challenge, I would say, your talent acquisition team on if there is any adverse impacts, and if we do need to reevaluate any of the policies or practices that we have in place. Okay, here we go. All right. So now let's calculate 4/5 together. So step one, right, um, is I created a scenario here. So to be a police officer, an applicant must be able to lift at least 100 pounds, right? The results in a certain amount of discrimination towards a protected group. So we have our policy, right? We have the job description. This is part of the fit test. So again, we have police officer. In order to be a police officer, you must be able to lift, goodness, at least 100 pounds. So right now, we're not talking about male, female. We're not talking about race or anything of that nature. We're just simply saying if you want to be a police officer, you got to be able to meet this requirement. Now we typically do that and we don't think anything of it, right? Do we think that this will lead to discriminatory impacts if we were just to simply go live with this job description? Now let's find out. So step two, we calculate the selection rate for each group. So we know applicants, we have 100 male for and 100 female applicants, right? So now we have hired them. So if you move down here, we have 100 male, we have 100 female. These were our applicants. We're looking really good there, right? Now we have made our selection. So now we have moved through the hiring process. We have hired these individuals, and we see that there were 80 male hired and there were 60 female hired. So now what we want to do is we want to calculate the selection rate. So what you do there is simply divide. I like to share with my cohorts that everything that you're going to do on the exam is a mathematical problem that is just going to include either adding, subtracting, dividing, or multiplying. You're not going to be dealing with exponents, the Pythagorean theorem, none of that. So we're just dealing with the basic mathematical functions. So in order to get to our selection rate, we simply divide. And now we can see that 80 out of 100, we get our 80%, right? Simple math here. And 60 over 100, we get 60%. So right away, we can see, and you probably didn't even have to do math to figure this out, but we can see that our highest selection rate is male, right? Because we're at 80%. So now we have done step three, which we've done the highest selection rates, and we've done our dividing. And then step four is to calculate the adverse impact ratios. So now what you're going to do here is you're going to simply take your 0.6 and you're going to divide it by your 0.8. And what do we get? Well, we get 75%. So we can see, and again, you can probably already tell just observationally if we're going to have adverse impacts. And so we see that 75%, right, is below the 4/5 or the 80%. So by performing this mathematical process, we would say that there is the potential, what we see here is that there is adverse impact for women and it does exist. Now, step five says determine if adverse impact exists. We just did that. 75% is less than 80%. So 80% is the goal. And according to the 4/5 rule, this can be used as evidence at adverse action. Now, remember what you, as an HR professional, if we are having these types of assessments, again, or what we have in policy, right, is for our police officer or any other job position that has a fit test or even in another requirement, we need to go back and look at the job description to say, are we excluding groups of people based on this requirement? And is this truly the requirement that is needed in order to perform the job that we are looking to hire? I have been with a good number of companies where I've looked at some of their pre-assessments and I'm like, they don't even do that on the job. Like, why is this a part of their assessment if that's not something that they're going to be doing within the job itself? If a police officer never has to lift 100 pounds, why would that be a requirement for a police officer to have to do, knowing that it is excluding, again, a group of people because we have performed the 4/5 rule? And so I just added this in here. So it does mean that a member of the less represented group is selected for a position less than 80% of the time. A member of the most represented group is selected for the same position. And so you would perform, and this would not be like a one-time thing, right? Because you're like, oh, maybe I don't know, maybe there's just not a lot of women in the workforce right now. We want to look at, our population where, is there interest with women actually becoming police officers? So we would do this a couple times. And then maybe again, looking at the job description to ensure again that the requirements of the role is what the incumbents will actually be doing and performing in their role itself. And so that is how you perform the 4/5 rule. So I'm actually going to back out of this slide so you can view the slide in totality. Any questions here? Cheryl coming in. So simply, lesser groups selection rate needs to meet 80% of higher group selection rate to show no adverse impacts. Correct. That is correct. So, and you would want it to be more, right? Because again, observationally, just looking at our applicants here, looking at our hires, well, yeah, we hired 80 males. So what? Oh, we only hired 60 females. Okay, so what? But you don't really get down into the nitty gritty until you start doing the math. Yep. Because again, just at surface level, you're just saying, oh well, we just don't get female don't want to be police officer, but that might not be the entire story. The story may be because you have adverse impact and you need to go and reevaluate your processes. Because now you run the risk of time over time, you're posting this position, right? You're saying, well, I'm not getting female applicants, or the ones I do are, they're sprinkled in, right? We're typically hiring males. Again, one of those female applicants that don't meet the fit test of 100 pounds may come back and say and feel that they were discriminated against. Well, I heard from inside that a police officer doesn't really need to lift 100 pounds. Or, I went across the way to another jurisdiction and their police officers don't even have that requirement in their job description. So now I feel that there's discriminatory practices with this police department here because you're putting in your job description that they have to lift 100 pounds. And I can't lift 100 pounds, nor do they need to lift 100 pounds. Does that make sense? Any other questions? And again, with any problem that you're going to encounter, this for a 4/5 word problem or any other word problem, just remember basic math. It's you're either adding, subtracting, multiplying, or dividing something. And then lastly, just to kind of drive this home before we round out this evening, remember for a 4/5 rule, you're looking for hires. More often than not, and I like to share this with all learners, when you have a word problem, they're going to give you details that you don't necessarily care about. So you're going to need to decipher on what you need in order to solve the problem, right? So again, this is going to be more or less in a table format. I know I have pictograms here. You're probably not going to have pictograms on your exam. It's going to be applicant column, 100 male, 100 female. They also may have it broken out into race categories as well. Maybe they have colors. Yeah, I've seen some with like yellow, pink, blue, white listed there as the applicants. And then you're going to have, again, a column for applicants and a column for hires. And you're really wanting to look at of course, the applicants and the hires because you're going to want to perform your division math there to get to your highest selection rate. Again, this one's pretty easy. Your exam may not be so easy, but to know that you're just going to take the hires over the applicants so you can get to your percent. And then you're just going to calculate the adverse impact. The adverse impact is simply just dividing these two numbers here. If it's below 80, adverse impact exists. If it's 80 or above, you're good. All right. Well, I'm going to carry on. This is actually, I think, our last slide that we have together. So according to the 4/5 rule, discrimination occurs when what? And I just looked at my time. I am so sorry. I did not realize that I have kept you all significantly past the ends of class. You all have been a really great sport about staying with me. I'm just carrying on. But yes, according to the 4/5 rule, discrimination occurs when the selection rate for any minority group is less than 4/5 of the selection rate for the highest group. You got it. Well done. Um, yeah, no problem, Andrea. Again, thank you all for staying on. I just happened to look at the time. I was like, oh my goodness. So yep, everyone have and I know it's like pre-4th of July as well. So I want to get you all out of here. Have a safe holiday weekend. Have a wonderful 16 weeks. You all are going to do amazing on your exam when you go to take it. And, maybe one day I'll be able to pop back in as well to see how you all are doing. Other than that, I will let you all go for the evening. And again, have a safe and wonderful holiday weekend.